A very good morning to all of you who are joining us for our monthly edition of the FSACCI Coffee Table. We're going to allow a few minutes for people to come in, but in the meantime, I'd like to welcome you. Today's aim of our coffee table is to provide an update on competition law. And more specifically, we're going to be unpacking competition regulation in Africa with a focus on South Africa. Which, as we know, places quite a special emphasis on things such as employment, as well as the promotion of small business. This is, again, particularly interesting given the recent Burger King saga. And here to talk about this is Lesley Morphet and Neill Mackenzie, who are both partners at Fasken Attorneys and experts in competition law. While we're waiting a couple minutes for everyone to join us, it's just gone 11 now. Lesley and Neill, do you want to maybe provide us a quick introduction? For those who have joined us already.
Thanks very much, Amy. So as you mentioned, my name is Lesley Morphet, and I'm a partner at Fasken and co-head the South African competition practice with Neill, who's joined us here as well. I'm quite new to Fasken though, having joined only a few months ago, but I have been practicing as a competition lawyer for many years, in fact, basically since the competition legislation came into force in South Africa. I deal with all aspects of competition law, mergers, prohibited practices, dawn raids and that. I deal with this both in South Africa and have also had dealings with respect to competition law elsewhere in Africa, particularly multi-jurisdictional merger filings. Neill?
Thanks, Lesley. And Neill, do you want to give us a brief introduction while we allow people to come in slowly?
Sure, thanks, Amy. Thanks, Lesley. So my name is Neill Mackenzie. As Lesley said, we together co-head the competition law team in the Fasken Johannesburg office. I've been at Fasken for my career thus far. I joined the firm in 2008 and save for 1 year when I went over and did my master's at King's College London, the competition law course there. I've been at the firm throughout and have a similar focus to Lesley, specializing in competition law and all aspects from merger control through to prohibited practice litigation and all aspects of compliance, training, dawn raids, etc. And I support the French football team, and I'm very disappointed at how the Euro tournament has developed.
Yes, I believe we have a British, well, English and Italian final. So we'll have to get together with our Italian counterparts chamber and organize something around that. Thanks very much, Neill. Thanks, Lesley. And thanks for lighting the mood as well, Neill. I think these coffee tables are usually in person over a cup of coffee and a croissant. And I think the distance makes things a little bit difficult. So please, to everyone who's joined us thus far, the aim of this is for it to be an interactive session. You have the expertise of Fasken, of Neill and Lesley for the next hour. So please make use of it through lots of questions, which you can post in the Q&A box, which is located at the bottom of your screen. Alternatively, you can also raise your hand. So I think we have quite a few more people who will join us. We started a little bit early, so I think we can maybe kick off. So let me just reintroduce the topic for today, and then I'm going to hand over to Lesley and Neill, who provide their presentation, their expertise. And then following that, I think we can have a nice interactive discussion session where we can address all your questions that come through on the chat, or alternatively, if you want to be brave and raise your hand, we'd love to see you and for you to introduce yourselves to everyone here today. So today's coffee table is about competition law. More specifically, we're going to be unpacking the regulation around competition in South Africa, which places that emphasis on employment, promotion of small business. This, of course, takes place within the recent context of the Burger King saga, on which the Competition Commission ruled. So on that note, I'd like to hand over to you, Lesley, and to Neill to provide us with your expertise. And then please, in the meantime, feel free to provide your questions in the chat box below, or make a note of them, and we will unmute you in the discussion session. Over to you, Neill and Lesley.
Thanks very much, Amy. So as you've mentioned, we're focusing on the public interest aspects of our competition law, such as employment, as Amy mentioned, particularly in the light of the recent Burger King decision, which highlights the importance of public interest in our law, something which is less of a focus in other more established competition jurisdictions, although it's interesting that many other jurisdictions in the world are starting to look with interest at public interest, particularly effect on employment. But we thought that this was an opportune time to discuss this aspect further. We're going to be looking at the public interest provisions in our legislation with a particular focus on mergers, particularly in the light of this decision, as we mentioned, and consider the implications of this and how to navigate the complications when doing business in South Africa and more widely in Africa. Public interest formed part of the bedrock of South African legislation when the Competition Act was first brought into effect about 20 years ago. It was thought necessary to bring it into force to correct the distortions of apartheid. And public interest has been adopted by other African nations quite enthusiastically in an attempt to overcome the historical disadvantage of their peoples as well. They tend to follow the guidance of South Africa, though. So we are going to be looking at how public interest is dealt with in South Africa and in Africa more widely. Turning first of all to South Africa, public interest features in a number of places in the Competition Act, and it starts with a preamble, which talks of the historical injustices and that the economy must be opened up to promote a greater spread of ownership and balancing the interests of workers, owners, and consumers. So the importance of workers and employment was foreshadowed right from the outset. An Amendment Act came into force a couple of years ago, which talks of the need to go further with public interest to promote economic transformation, stimulate the growth of small, medium enterprises and firms owned and controlled by historically disadvantaged persons, while still protecting employment security, and worker ownership. And there are numerous other references to public interest in the legislation. I'll leave Neil to take us through those.
Thanks, Lesley. So I think that's a very good place to start by looking at in all of the introductory portions and explanatory portions of the Act. There is this very strong recognition of the public interest. And then when it comes to the actual operational points within the Act, you see, as Lesley says, the public interest featuring in a number of areas. So first of all, in the abuse of dominance provisions, you see new buyer power and price discrimination rules, which have been introduced in recent times, which are specifically aimed at promoting participation of small firms, medium firms, and firms owned or controlled by historically disadvantaged persons, rather than promoting competition overall, which would be the usual basis for abuse of dominance rules. And then secondly, in the market inquiries legislation, you see specific mention of when the Commission is conducting a market inquiry, they need to look at barriers to entry and participation by small firms and firms owned by historically disadvantaged persons. Similarly, we now see in the exemption provisions of the Act, there are areas where you can now obtain exemption from the application of some of the provisions of the Act if the conduct which you want to carry out achieves growth in employment, increased participation of small firms, and transformation in the specific sector. And then in addition, you see when a firm has been found guilty of a competition law contravention, one of the factors that must now be considered in determining the extent of the fine, the administrative penalty, is the extent to which the illegal conduct affected the ability of small firms and local firms to participate. So sprinkled all across the operational provisions of the Act, you do see this quite strong recognition of the public interest, employment, small firms, and promoting entry and participation by firms owned by historically disadvantaged persons. But most importantly, where the public interest really comes to the fore and is a focal point for practice and enforcement by the competition authorities, is around merger control. So Lesley, perhaps you can pick up that topic and just introduce the way the public interest fits in together with the competition law test. You're on mute, Lesley.
Sorry, well, thanks very much, Neil. Yes, mergers, I suspect people are quite familiar with them, but just to recap how the merger process is conducted under our competition law, any M&A transaction that amounts to a merger as defined has to be notified to the competition authorities if it meets the thresholds. And they have to wait until approval is obtained before transactions can be implemented. It will be relevant later to understand the different thresholds of mergers and how those are adjudicated. So just let me briefly explain. They are categorized as small, intermediate, or large. Small mergers don't automatically need to be notified, although the Commission can call on the parties to notify and obtain approval before implementing them. Intermediate mergers, which are determined based on the assets and turnover of the parties, lower thresholds than those for a large merger. Intermediate mergers are decided by the Competition Commission. So one notifies the Commission, they assess the transaction, and they decide whether it can or can't be approved. Large mergers are submitted to the Commission. They investigate the merger, but they then have to refer it to the tribunal for a decision. Intermediate mergers have a fixed assessment period of up to 60 business days, after which the Commission has to conclude whether the transaction can be approved or not. Whereas large mergers are much more open-ended. They have 40 business days, which can be extended, and even once they refer to the tribunal has open-ended periods in which it can decide on mergers. So those can be much longer in duration. Either way, filings are submitted to the Commission, which analyzes the transaction from both the competition aspect and from the public interest perspective. From the competition law perspective, they look at factors to see whether the merger might be problematic because it is likely to substantially prevent or lessen competition by assessing factors such as barriers to entry, import competition, how concentrated the market is, how dynamic the market is, that sort of issue. If it is likely to lessen competition, then they look at whether it can be justified on the basis of technological or efficiency grounds that mean that despite the fact that there are going to be fewer competitors, it's nevertheless not going to be problematic from a competition perspective. But then they still have to look at the public interest factors, which Neil will take us through.
Thanks, Lesley. So that's absolutely right. So once the Commission has looked at the competition implications of the transaction, what the Act then says is that they must assess whether the transaction can be justified based on substantial public interest grounds. And then what it does is to list a number of specific factors relating to the public interest that the authorities must take into account. So what are those factors? So first of all, the impact of the merger on an industrial sector or a particular region. Second, the impact of the merger on employment. Third, the ability of, the impact of the merger on the ability of small and medium enterprises and firms owned or controlled by historically disadvantaged persons to enter, participate, and expand in the market. Fourth, the ability of national industries to participate in international markets. And then finally, and particularly topical at the moment, is the impact of the merger on the promotion of a greater spread of ownership, in particular to increase levels of ownership by historically disadvantaged persons and workers in firms in the market. So I think just to flag one point about that final bullet point around promotion of a greater spread of ownership, is a couple of quite indicative words in there. So it's talking about the impact of the merger on promoting a greater spread of ownership, in particular to increase levels of ownership by historically disadvantaged persons and workers in firms in the market. So that promotion and increase is a theme which we will come back to. But perhaps, Lesley, why don't you take us through how the competition test and the public interest test are weighed and balanced against one another?
Thanks, Neil. Yes, so as you can see, they have to look at both the competition aspect, whether it's substantially prevents or lessens competition, and also the public interest factors. And it's a balancing act that the authorities have to conduct in deciding whether a transaction can or can't be approved. So the public interest aspects could possibly redeem an otherwise anti-competitive merger if it was going to have create a vast number of jobs, for example, or really kickstart an industry. But in either event, it has to decide if the merger can be justified on public interest grounds. So there is also, it has always been theoretically possible that an otherwise unproblematic merger could be prohibited on public interest grounds, although it has never happened until now, and with the Burger King decision breaking the mold. Public interest concerns have virtually always been addressed through conditions. We used to say public interest concerns are capable of being remedied. For example, you give undertakings not to retrench employees for a certain period. But as I say, since June this year, last month, we now have an example where a merger has been prohibited and conditions haven't been found satisfactory. We'll get to that shortly. The public interest aspects are, I suppose, the domain of the Minister of Trade, Industry and Competition. He's the minister in charge of the competition authorities, and Neil will take us through his interest in these matters.
Thanks, Lesley. So I think the point here is that and it's something that we'll come back to, is that the Minister of Trade, Industry and Competition, as Lesley says, his participation and the participation of his department in the merger filing process before the competition authorities is becoming an increasingly important aspect of merger control in practice in South Africa. And it certainly developed during the last year or so quite substantially. But we'll pick up on a number of practical points around the minister's participation. But just to set out by way of outline, what does the Competition Act actually say about the minister's participation in merger control? Well, there are a couple of things. First of all, in relation to large mergers, the minister has the right to receive a copy of the merger notification. So when you submit your merger filing to the Competition Commission, as a matter of course, they will provide a copy to the minister, Minister Patel, currently. Second of all, whether it's in relation to an intermediate or a large merger, or indeed a small merger, the minister has the right to participate in the process of the Competition Commission or the Competition Tribunal in order to make submissions on any aspect of the public interest. And then finally, the minister now, under the recent amendments to the Act, has the right to appeal. So a number of practical aspects of involvement that the minister now has, which essentially in practice mean that it's increasingly important that it's not only the competition authorities who have to be satisfied that the merger is acceptable, but in addition, one has to engage in detail with the minister and his department. So I think that gives a very short overview of what the public interest issues are, how they fit into the test, under the merger control aspects of the legislation in South Africa. And before we come back to some of the practical issues and strategic issues around how to manage the public interest components of the Act in South Africa, I think this is probably a very useful juncture for Lesley to just jump in and just take us through some of the issues around treatment of the public interest in other African countries aside from South Africa.
Thanks, Neil. As I mentioned earlier, other African jurisdictions are very interested in the public interest aspects of competition and introducing the public interest test. And although the law is most developed in South Africa, because there have been a number of cases on the point, there are other jurisdictions that are becoming more and more active in promoting public interest. For example, Namibia, which has wording similar to ours in respect of public interest, has for years been protective of employment and has introduced conditional approvals subject to employment conditions. I remember about quite a few years ago, I was involved in the Anglo Gold Ashanti sale of their gold mine to Guinea Fowl Investments, and the competition authorities were very insistent that there should be no retrenchments for a period. In the Walmart Massmart case, which was a seminal case in South Africa, but also had to be cleared in Namibia, although there wasn't a great deal of activity of the parties in Namibia, the authorities also sought to impose public interest conditions, amongst the requirement of no employment losses. There was also local participation to increase the ownership stakes of historically disadvantaged persons, although that was litigated all the way to the Supreme Court of Namibia. And then in a more recent decision, when the China National Uranium Corporation bought the Rossing uranium, there were a number of public interest conditions introduced. The usual no merger-specific retrenchments for 2 years. There was a requirement to keep a very high ratio, 95%, of local to foreign employees. And in fact, from a management perspective, they were supposed to be only employed on fixed-term contracts, had to ensure that their procurement policy did not have a detrimental effect on local suppliers and that it benefited local procurement. They've also published a competition policy talking about their public interest objectives to safeguard investment and employment, promotion of interest and market opportunities for small firms, promotion of ownership for spread. These are all concepts that you've heard Neil describe in relation to our South African public interest focus. Botswana has also a public interest element to its competition regulation. And there too, they have been considering employment and citizen empowerment. There have been a number of mergers requiring a moratorium on retrenchments. And I've been involved in mergers also where it is, where a Botswanan owned entity is selling to somebody outside. The Botswanans are particularly keen that there should be an element of local ownership remaining, despite the seller selling to an external acquirer. Nigeria also has similar provisions in its legislation, and although they haven't been had as much experience implementing them, it's very clear that they are focusing on consumer and public interest benefits when looking at their legislation and the implementation of it. Then there's Kenya as well. It has the discretion to take non-competition factors into account. The legislation is there also very similar to the wording in South Africa, which includes the effect of a transaction on a sector or region, on employment, and on the ability of small businesses to compete. And in the Telkom Kenya Aircom merger, the Competition Tribunal, which was recently established, recognized the need to put safeguards in place in respect of public interest effects through the use of conditions. Mozambique, which has very recently brought its legislation into force, also has public interest considerations to take into account. And given that they all have very similar legislation, I would anticipate that they will also be focusing on public interest, just as the other legislations I've referred to. And it's not restricted to national jurisdictions. COMESA also is interested in public interest aspects. The wording of their treaty talks of public interest, and although public interest in that context leads one to conclude that they are focusing on normal competition and consumer issues. However, I was in a seminar with the then head of mergers, who's now the acting head of the whole authority, who was asked a question about whether they considered that they had the ability to consider public interest aspects. And he said that they are very definitely of the view that they can and will consider public interest aspects when regulating mergers. So one can see that South Africa is not alone on the continent in focusing on public interest. And when one's doing business in Africa, one definitely has to take these aspects into account. So unpacking public interest more, let's come back to South Africa and look at the evolution of the public interest test in South Africa. I think the most important, very early case in this regard, which I think is also very relevant in the light of the Burger King case, is the Shell TEPCO matter. In that case, Tebe Investment Corporation, which is an investment company controlled and owned by historically disadvantaged persons, was selling its subsidiary, TEPCO, to Shell South Africa. Shell South Africa was seeking to buy TEPCO to enhance its empowerment credentials, whereas TEPCO was struggling economically, and in the absence of alternative funding solutions, it decided to sell TEPCO to Shell. The Commission was concerned that a company owned and controlled by historically disadvantaged persons was being sold to Shell, which wasn't, it was a, if one can call it, a historically white company, and that a black-owned brand would disappear from the market. And it was a large merger, so the Commission didn't have the final decision-making capability that was in the hands of the tribunal. But the Commission recommended to the tribunal that the tribunal impose conditions, including the requirement that TEPCO continue to exist, although it would be jointly controlled by Tebe and Shell. The tribunal was very concerned about this approach and agreed that this effectively discriminated against Tebe, which was a black empowered entity, precluding it from concluding agreements that suit its commercial interests. And as they said, the Commission's role is to promote and protect competition and a specified public interest. It is not to second guess the commercial decisions of precisely that element of the public interest that it is enjoined to defend. And went on to say that the role played by the competition authorities is at most secondary to other statutory and regulatory interests. In this case, the Employment Equity Act, the Skills Development Act, and the Charter itself. And they said the competition authorities, however well-intentioned, are well advised not to pursue the public interest mandate in an overzealous manner, lest they damage precisely those interests that they ostensibly seek to protect. The case law developed further from there. Neil, do you want to take us through that?
Sure, thanks, Lesley. Perhaps just very, very briefly to mention possibly the most famous public interest case that South Africa has seen was the 2011 takeover of Massmart by Walmart. There were a range of public interest issues which were at stake there. The key one was around a suspicion that post-merger Walmart would take the South African supply chain of Massmart and effectively substitute it with Walmart's global value chain, which they saw to be more efficient. So that obviously attracted a lot of public attention. What I'm more interested in, and I think for purposes of this discussion, is really two quite interesting quotes that come out of the authorities in that case. And the first one is really, it just articulates really nicely an important principle that always was considered critical in this kind of analysis, which said basically that public interest issues need to be merger specific. So the tribunal said, unless the merger is the cause of the public interest concerns, we have no remit to do anything about them. So in other words, any public interest issue must be merger specific before it can be considered. And then the second one, which has become a rather more famous quote in competition law jurisprudence, was the tribunal saying, our job in merger control is not to make the world a better place, but only to prevent it becoming a worse place as a result of a specific transaction. So in other words, the law should be there to prevent harm being caused by the merger. And it's not about trying to promote proactively any government policy or public interest objectives. So this was a 2011 case, and one sees off the back of that a range of predominantly foreign takeovers of local South African businesses, AB InBev's acquisition of South African breweries, the Coca-Cola bottling transactions, Glencore's acquisition of Chevron, PepsiCo's acquisition of Pioneer Foods, all which saw a really detailed engagement with the competition authorities and with the minister over a suite of remedies designed to deal with public interest issues. Perhaps let me pause there. I was going to run on to, moving from this jurisprudence into the current practice, but Lesley, is there anything that you would like to add there before I do that?
No, Neil, I think that's covered it pretty clearly. Thanks very much.
Okay, perfect. So I think that gives a sense of some of the principles that have come out of the case precedent and the practice around public interest over the years. So that brings us to essentially the question of where are we today? The current practice around enforcement of the public interest components of the merger control test. And I think to summarize it, our sense is that the public interest components in the Competition Act are being taken more seriously today than they ever have been before. In order to try and give some understanding and context around this, there's a useful quote, which was, it actually comes from a corporate breakfast where the commissioner of the Competition Commission, Thembi Nkosi Bonakele, was the guest speaker. And in lecturing the students at the University of Johannesburg, I always say this quote because I think it really gives you a lot of insight as to the enforcement approach of the authorities. Mr. Bonakele said, I see the Commission as an agent for social and economic change. Really simple, short quote, but I think a couple of interesting things about it. The one is quite obvious. What he's saying is that public interest, economic and social change is a priority for the Commission. He's not saying, I see the Commission as solely a protector of low prices and consumer welfare. And he's not saying that he sees the Commission as only an agent for ensuring competitive markets. He's saying that he sees the Commission's mandate more broadly to one which is economic development overall. And the second point is slightly more subtle. What he didn't say is that the Commission is a protector of the status quo, or that the Commission is there to ensure that corporate conduct does not harm the public interest. The suggestion is that where possible, the Commission is a catalyst for change. So some aspect of the Commission's mandate, which is proactive to try and find opportunities for positive change and not just to prevent harmful conduct. And when one thinks about these sentiments against the background of a recent policy statement by the Department of Trade, Industry and Competition, which says essentially that they view competition policy as aimed at industrialization, building dynamic firms, protecting and creating jobs, and promoting economic inclusion and transformation. It really gives you a nice sense of, at the moment, the lens through which the enforcement authorities are seeing the public interest, the role of the public interest in merger control. So as we mentioned earlier, during the last 12 months, we've seen an unprecedented involvement of the Department of Trade, Industry and Competition in merger control processes. And on the 20th of May this year, 2021, the DTIC has, as I mentioned, published a policy statement around the role that they see competition law playing in their overall industrial development program. And they identify a couple of specific themes that they say policymakers will aim to achieve through merger control. And those are employment. So they say they're looking for pro-growth outcomes and expansion of education and skills development. The second is broad-based ownership, so seeking a greater number of Black South Africans drawn into ownership of firms, and specifically mentioning a focus on promotion of employee and worker ownership arrangements accompanied by board representations. And then in addition, the policy talks about supply development and localization. The next point is investment. So they aim to use merger control to promote deeper and higher levels of investment to enhance the ability of local industries to compete internationally. Downstream beneficiation is another goal of the policy. And then finally, there's a kind of a catch-all, which says, depending on the sector, we might try to find other aspects that can be enhanced through the merger control process. And they give the examples of greening the economy and expanding exports. So you do see through all of this a kind of a moving away from that Walmart statement of the merger control shouldn't be trying to make the world a better place. Here we see it, in fact, some of the language that comes through from the way the Commission sees its role and the way that the DTIC sees the role of merger control. There is certainly an undercurrent of seeking opportunities to promote proactively the public interest. So in the current practice, what do we see? Well, it's mostly in relation to acquisitions by foreign acquiring firms, sometimes in relation to mergers between prominent local South African firms, and sometimes even high-profile foreign-to-foreign acquisitions. It's becoming increasingly common that one sees the Minister and the Department engaging with the Commission and requesting commitments from merging parties. So in some instances, you'll see the Department raising specific public interest issues. Sometimes you'll see a loose mention of the transaction impacting the public interest and then a request for commitments. And sometimes one simply sees a request for commitments. And then you see in the conditions imposed by the Commission and the Tribunal, it's becoming increasingly common for the Department to request monitoring, consultation, involvement in administering the conditions. So certainly from the Minister and the DTIC's perspective, at the moment we see a really strong involvement and a strong statement of an intention to use merger control more proactively. A couple of other points around current practice. I think that one does see this interesting contrast of some transactions where you see public interest issues arising and being addressed on what you might think of as a one-for-one basis. So in other words, the merger which might adversely impact employment, well, that can then be addressed by a condition prohibiting retrenchments for a particular period. If a merger reduces ownership by historically disadvantaged persons, well, then a condition can be imposed to essentially have the acquiring firm commit to divest a shareholding to historically disadvantaged persons. So a one-for-one approach, public interest concern met by a particular condition. And the alternative approach that one sees is the kind of the broad suite approach. So if you look at the cases, PepsiCo, Pioneer, etc., where one sees an overall package of remedies negotiated with the government that address the full range of public interest issues identified by the DTIC's policy document and becoming part of the order of the tribunal. So there is a sense in which one does find oneself in those circumstances dealing with conditions to promote all aspects of the public interest rather than addressing specific concerns. So that's primarily a couple of points just around the role that we see in practice of the Department of Trade, Industry and Competition playing in merger control. And I think it's also fair to say that at the moment the Commission is particularly strong and that they've always taken the public interest very seriously, but certainly we are seeing strong enforcement of the public interest by the Commission. And I think there's no better case to illustrate that than the recent Burger King case, which perhaps Lesley, you can take us to.
Yes, so why all the interest about this Burger King case? What was it about? Well, it was, as I mentioned earlier, it was the first transaction to be prohibited based on public interest grounds, which is a major development, and it's drawn significant attention and debate. So the facts in this case, from what we understand from the publicly available information, is that the seller, Grand Parade Investments, which is a historically disadvantaged entity. So let me say it's a company controlled by 68% of the shareholders were historically disadvantaged people. So it was a historically disadvantaged seller selling Burger King South Africa to a private equity entity, ECP Africa, which has no ownership by historically disadvantaged persons. There was no competition concern. ECP Africa didn't have any activities that would overlap. There wouldn't be an increase in concentration or any vertical issues because one entity supplied the other, for example. No competition issues whatsoever. The focus was purely on the public interest aspects. And as you can see from what I've said, because the acquirer had no BEE shareholding, whereas the seller was BEE controlled, the level of ownership in the target firm by historically disadvantaged would reduce essentially from 68% beforehand to 0 as a result of the merger. The Commission was very concerned about this change in empowerment, if one can put it that way, and concluded that this was problematic and a major hurdle from a public interest perspective. The merging parties apparently made a number of proposals to address the public interest concerns and to produce public interest benefits, basically. They offered to invest 500 million rand in new Burger King stores in South Africa in the next 5 years, to increase the number of Burger King stores in South Africa by 150, to increase employment by at least 1,250 historically disadvantaged persons, to increase the payroll by at least 120 million rand, and to increase procurement from historically disadvantaged person-owned firms by around 300 million rand per year within 12 months. and they undertook to allocate 5% of the shares to BEE shareholders within 24 months. It also needs to be understood that the sale was taking place against the background that Burger King was experiencing financial difficulties and had been looking for a buyer for a while. Obviously Grand Parade Investments were very keen to conclude the transaction. Therefore, the wide suite, I would say, of public interest benefits that were offered. Notwithstanding this, the Commission concluded that on the simple basis that the ownership in the target would reduce from 68% empowered to 0, meant that the transaction could not be justified on public interest grounds. So, having concluded that there was no competition concern, but there was a major public interest concern, they felt that that outweighed any other aspect, and the public interest concern meant that they prohibited the transaction. And being an intermediate merger, that is the end of the matter unless the parties take the transaction to the tribunal on reconsideration, which, as I'm not aware of whether they are or aren't, but that would be the next step in the process. So against that background, perhaps Neil, you have some comments to raise?
Thanks, Lesley. Yeah, I mean, very quickly. I think one of the things which is quite interesting about this is it goes to what we mentioned earlier about the two different approaches. You've got the broad suite of public interest conditions approach versus what you can think of as the kind of one-for-one approach. And so here, what you've got is there's one public interest issue, which is the adverse impact on the ownership stakes in the firm by historically disadvantaged persons. In this case, it appears that that particular issue couldn't be remedied on a one-for-one basis with, just committing to put essentially back in the BEE shareholding, which would be lost. So instead, what the parties offered is this broad suite of conditions, some investment, some creation of employment, increasing the number of Burger King stores in South Africa, etc. And from the decision, it appears that what the Commission is saying is essentially that doesn't work for us. There's a reduction in BEE shareholding, and it's not remedied through all of these other offers that you're making, and so our public interest concern is left unaddressed. So in some sense, that's kind of fair enough. From the Commission's perspective, it's quite a difficult situation for them to be in, to have to say, okay, well, we've got a 68% reduction in BEE ownership, but on the other hand, we have 120 million rand of additional payroll, 500 million rand in new Burger King stores. How does one weigh up those different things? In other words, what is the cost of the reduction in BEE ownership? So the Commission is saying, well, that assessment is too difficult. We can't compare investment to BEE ownership. So in the one sense, one can certainly sympathize with the Commission and understand why they came to the decision that they did. The approach that they, I think, would have preferred, which is one where there's just an increase in BEE shareholding tendered by the acquiring firm, would give some certainty. So in other words, in future, you would know if my merger reduces BEE ownership by 20%, I can then commit to increase the BEE ownership in the acquiring firm by 20%, and then I meet the concern. It gives some certainty. It's not perfect, but it avoids that really difficult value judgment that the Commission would otherwise have to make. I think that perhaps against that, that's just one initial comment, which I think it shows. This case shows the difficulty with the current practice that's developed over the last 12 months, But I see we are slightly pressed for time. So perhaps, Lesley, I'm not sure if you had any additional comments to make on Burger King. And then the next topic to discuss was just to run through what are the implications for business and how one navigates the range of complexities that can arise in this area.
Thanks, Neil. Yes, I think that this is one extreme of how to balance public interest with competition issues. And I do have a concern that this approach can be very harmful to black shareholders, which is a situation that the tribunal warned against in Shell TEPCO. I think that the approach is quite starkly contrasted, and I certainly would sympathize with BEE shareholders who are struggling and need to sell, maybe finding it rather difficult to make that sale under these current circumstances. I think it's brought in some uncertainty as to how one will deal with factors, particularly given, I think, that in the cases that you were discussing earlier, it's apparent that the minister is very keen to develop public interest benefits as a whole. So perhaps the suite approach rather than the one-for-one approach is what perhaps people were being led to conclude was the way to go. I wonder, I think perhaps what might have happened, given, as I said earlier, the intermediate mergers have a finite period, it's perhaps a pity that this wasn't a large merger, because one might have found that conditions could have been hammered out between the parties or at the tribunal, rather than the blunt instrument of a prohibition. But it does lead one to ask, as a business person, how does one deal with this in future? I think you need to structure transactions with your eyes open. You now need to understand that public interest is a very serious factor, and you need to take it into account and decide at the outset, when you're structuring your transaction, how are you going to tackle the public interest factors that might arise? What is it that the DTIC might be seeking? Engage with both the DTIC and the competition authorities as you go through the process, and try to reach agreement on suitable conditions that are satisfactory to you as early as possible. Obviously, it will depend on the nature of the deal and the particular dynamics involved, but these are actual problems that you might encounter to have to deal with. I think one could consider, are there actual problems that need to be remedied? And if so, what is the remedy that one needs to offer? Are there opportunities for proactively promoting public interest? What is one willing to and able to put forward in order to get the merger through? And remembering that it's not just in South Africa, but if you have a transaction that is impacting a number of jurisdictions, this is an issue that's going to need to be navigated across a number of jurisdictions. But I think the really important thing is to think about is plan ahead. Don't leave it to the 11th hour to be offering remedies. Have you anything to add to that, Neil?
No, I think that's all absolutely right. I fully agree. And I see that Amy wants us to wrap up, and soon she will just start muting us. So the only very quick final point I would make is that we do also have in the Competition Act this new provision around national security. So a linked but separate process to the competition approval process, where a lot of these issues might become common ground. And it's the kind of national security protection that one sees in other jurisdictions. And in due course, once that provision becomes effective, it might be that we are supplementing the current practice with best practice from probably our colleagues in Canada and other countries who have a separate national security dimension, which adds to the public interest considerations that one needs to take into account. That was all I thought I might add.
Thank you very much, Neil and Lesley, for that very informative, particularly for someone who's not in competition law, very informative update on what's happening at the moment and I think some of the conflicts coming through. I don't mean to stop you short. I would just like to provide some opportunity to go through some of the questions that we've received thus far and to provide the opportunity to those joining us live today if they have any questions that they would like to pick your brain on. Of course, I'd just like to take this opportunity. If there are any lingering questions that we don't have the time to deal with today, please do pop myself an email or any one of the SACCI team members, and we'll gladly put you in touch with Fasken as well. They've kindly agreed to assist where possible on their side in answering any of your questions. With that in mind, I'd like to open the floor. I see we have quite a few big companies as well before I go to the social media questions. I see Danon is here, welcome. I see Legacy Hotels is here. Irvan is here as usual. Thank you always for attending our coffee tables. So the floor is yours. If there's any questions, please do raise your hand and we can unmute you and we'll deal with those ones first. Olivier is here as well. Welcome, Olivier. Melanie, welcome. So are there any questions from the floor? Just to put you on the spot here today, as you are our immediate audience. Anyone would like to ask any questions to Fasken? Please don't be shy. We welcome anyone with a cup of coffee or their pajamas as well. There's no rules in lockdown, as they say. Okay, all right, nothing so much. I'm going to move to the questions from social media. And if those who have posed their questions will forgive me, just for purposes of time, I'm just going to group some as there's some recurrent themes coming through. So the first one I think deals particularly, these are from our French companies or our international companies coming in. So element of investment here. So just for the first question, let's see from Philip here, we have, is there any link or implication to the African Free Trade Agreement? If so, what are the implications? I think you mentioned just in your closing statement, Lesley, that there was some to check across jurisdictions as well. So with the new African Free Trade Agreement, is there anything that companies need to consider, or are there any implications around competition law on that topic?
Well, competition law is going to be covered as part of the trade agreement. It's an aspect that everybody agrees needs to be dealt with. But it's not, I don't think, at a sufficiently advanced stage that one can say, take this particular factor into account. I think one has to more generally look at the competition regimes of the individual countries across Africa. They're very similar in many instances, as you've heard me say, but there are very important differences, and also differences in how countries interpret their legislation. I remember being on a call with representatives from 3 different countries with wording of the legislation very, very similar, but there were different approaches. I think the free trade approach of harmonizing will be very useful in future, but I think at the moment one has to look at individual jurisdictions and of course the regional authorities such as COMESA and ECOWAS and CMAC, amongst others.
All right, thanks very much, Lesley. Then just going on to the next one. There's quite a few regarding this one. I think it brings up a keen conflict that you've already highlighted. But what does this mean for competition, investments, when you have a big push by government? We have the investment summit coming up towards the end of the year, a big push for foreign direct investment, as well as, of course, a big push in promoting small business. And I think this is particularly highlighted within the COVID-19 context as well, and trying to support small business on that side. What do you think the implications are on that? I hope I've summarized that question accurately enough for all those who've asked similar ones.
Neil, would you like to take that, or shall I?
Sure, I could venture a view, and then you jump in and add any additional thoughts you have, Lesley. I mean, I think that it's a very good question and very topical at the moment. And I think it's an unavoidable fact to recognize that there is a trade-off here. You know, the public interest components of the merger control test are additional obligations on businesses coming into South Africa. I think that when one looks at it from the perspective of the government, the rule makers and the enforcers, what they say is, okay, that's recognized on the one hand, but on the other hand, the traditional approach and rules which have been used over a number of years have just not yielded the economic transformation and change that we want. We still see this high unemployment. We still see difficulties in small firms entering into and participating in markets. We see unsatisfactory levels of BE ownership across the economy. So we've got to do something. We've got to use whatever tools are available to try and unleash this entrepreneurial capacity, which is currently sitting in businesses which are struggling, unemployed people, and we need to try and do what we can to promote this aspect at the same time as encouraging investment. So I think that the way that the government probably sees it is that one needs to broker a middle ground, and that's where these public interest negotiations and conditions come in, where transactions are, in the most part, I mean, the Burger King case is exceptional. For the most part, transactions are approved. So companies are getting their permission to go ahead with their acquisition. But at the same time, there is this recognition, on the other hand, that one needs to be mindful of promoting the aspects of South African policy which are not automatically catered for by simply investing in local firms.
Yeah, I think the message would be that it's not impossible at all to conclude transactions successfully in South Africa. It's a question, though, of I suppose, coming to the party as far as the authorities are concerned. And it's not unique to South Africa. I mean, other jurisdictions have these kind of promoting the good for their own country in different manners. And interestingly, I was on a discussion recently with some lawyers in one of the leading countries in the world, worrying about perhaps the effect of COVID on employment, and should they be introducing a public interest test there. So it's far from being unique to us. I think we're leading the world in this respect, perhaps, and other countries are now becoming very interested in it. And I think something else to say is a benefit of it, at least as part of the legislation, it's understood, and it is and you're dealing with a specific process. You know what it has to be. It's not sort of reaching a deal in the back room that isn't regulated by the authorities, if one can put it that way. So I think it's better that it is as part of the process.
Yeah, fully agree.
So I have another question. Sorry, Neil.
I was just going to say one thought just came to mind, which I think is potentially important, is that these kinds of obligations agreed through the merger control process are not all negative. There is certainly a way in which the commitments brokered with the authorities and with the government can be framed in a very positive way for businesses entering into and doing business in South Africa. In the same way that currently issues dealing with carbon emissions and demonstrating that one is doing the right thing and as a responsible corporate citizen, when one is brokering these deals with the South African government to remedy competition and public interest issues, there is certainly a way of framing those commitments which can be beneficial and demonstrative of an openness and a transparency to work with government, to commit with South Africa, that can certainly offset some of the costs that might be involved.
Thanks for that, Neil. I'm glad I didn't cut you off, because it's always an important thing for us to be able to promote South Africa in a good way and make sure we do attract some of that investment, at least from our side. I have another question which I believe may lead on from what you've just said here. So I have a question that states, how influential are trade unions in the competition process and relationship with DITC?
So trade unions have to be are entitled to participate in the process, and it depends on the trade union, how involved they will become. Essentially, in the process, when you file your merger, if there are affected, the employees of the parties belong to trade unions, then you have to notify those trade unions of the transaction, and they are able to participate and do. Some trade unions are particularly active, others are fairly relaxed about transactions. But generally, one is having to engage with them as part of the labor process as well. And for the most part, the process runs pretty smoothly.
Good to hear. I'm sure there will be music to the ears of some of the people here today. Remember, if you have any questions from those online directly, please do pop us a Q&A or raise your hand and we'll unmute you. Okay, I think that dealt with the main questions regarding the more investment side. I have another one, which is, I think, more of a comment. I believe, actually, Neil, you mentioned this. You mentioned national industries in foreign markets. The questions ask if you can expand on that. I don't know if you require more context, but so I think it's looking at South African industries within other foreign markets. I think that was something you mentioned. Sorry, I don't have much more context in the question than that. Does that make sense, or should we move to another one?
Sure, yeah. So, I mean, that was right back at the beginning. I did mention that is one of the 5 public interest factors that the authorities are obliged to take into account, is the impact of the merger on the ability of local industries to participate in international markets. Surprisingly, that's one which one doesn't see a tremendous amount of enforcement activity around. And it's also one where if you look at the DTIC's recent competition policy document, there's no specific goal around promotion of the ability of national industries to compete in international markets, but it's one which a number of the other policy targets seek to achieve essentially indirectly.
Yeah, I was just going to say, if I can chip in here, I think that's what is known as the so-called national champion argument, that you need to be strong in your own country in order to compete globally. I know that the previous chair of the tribunal, David Lewis, he was very skeptical of that as an argument. His approach was really, if you're not able to compete locally, you're needing help to compete locally, then how are you going to compete on the global stage? So that might be why it's underplayed to a certain extent as an argument.
All right, thanks very much. Just for the purpose of time, I think I'm going to take one last question. So there were quite a few regarding the Burger King situation, but I think they came through before you did your explanation, Lesley. So if it hasn't been dealt with here, I think one was regarding a comment that it prejudices Black shareholders. I think you did touch on that. If we haven't answered your question on that, please do shoot me an email and I'll get in touch with Fasken to make sure we relay the correct information. I'd like to ask one last question that came in, which is quite unique. They state that they're not sure if it's a competition case. However, there's been quite a bit of media lately regarding Amazon, who is planning to develop on indigenous, I quote, indigenous land in Cape Town. It may not be competitional, but definitely public interest. And the specific question regarding that is, what takes precedence between BEE and land as a public interest question?
I'm not sure that I've come across one with BEE and land coinciding. The Amazon question, I think, is definitely not competition.
Apologies,
related.
I left the most interesting one for last. I thought I had to ask that because we've dealt a lot with BE and employment and small business, but also BE and land. What's your opinion? What would take precedence on that, or maybe just to give a bit of context on the situation?
I'm not sure what you think, Neil, but my question would be where the land would come in as one of the public interest aspects that have to be considered from a competition law perspective. I'm not sure that I can see a context in which it would be one of the factors that would be weighed up. I suppose it could be an effect on a particular region, but one is looking more on the commercial aspects of it than protecting land, which I think is different legislation. I don't know what you think, Neil.
Yeah, it's a good question. The only thing I could think is that in the factor which says you need to look at the impact of the merger on the promotion of a greater spread of ownership, it says in particular to increase levels of ownership by historically disadvantaged persons and workers and firms in the market, but not exclusively. So perhaps one could argue that the spread of ownership does not only mean corporate ownership. You could be talking about ownership of land as well.
I'm not sure where that would come into the merger, though. That would be a really interesting one.
I think something to keep an eye on as we see the development of the land bill, which is ongoing, of course. So maybe we'll grab you back in a couple of months and see if we can better answer that question to whoever posed it. I'm actually not sure. So thank you for providing us with that last question there. Before we wrap up, I just want to say, is there any last leaving comments you would like to communicate to the participants here today that they should ultimately leave with before I close today's session?
I suppose my last comment would be what I've said earlier: plan ahead. If you're going to enter into a transaction that involves South Africa and or other jurisdictions in Africa, plan well in advance and try to anticipate the issues that might arise and to deal with them, the remedies at an early stage.
And on your side, Neil, any closing comments?
No, nothing from me. Just to thank everybody for the opportunity.
All right,
and as you said,
that does, yes.
Sorry, and as you said, Amy, if anybody does have any questions, if they can pass them on to you, we'd be happy to try and cater for them.
All right, fantastic. And that does half my job. So I'd also like to thank, well, first and foremost, to our experts for lending their expertise here today. It's always great to be able to have this pool of leading experts within the network in the community. I think it's of great value to all of us here today. So thank you very much for your time and for lending those expertise. A big thank you to those who have joined us here today and those who've interacted with us via social media. It's always great. We wish we could see you in person. However, when things calm down, we invite you to come have a coffee in our new office, which is in the same building and just happens to be right next door to Fasken. So while you're at us, you feel free to drop by at Fasken. I'm sure they'd be happy to meet you in person as well. So on that note, thank you very much. Keep a lookout for our next coffee table, which will take place on a monthly basis. We'll keep you updated on all our communication. In the meantime, I wish you a very good afternoon, and please do stay safe and do reach out if you have any requirements of business support, particularly during this time. We know it's challenging, but the SACCI team is on hand and here to support you. So thank you very much. Have a good day. And thank you, Lesley and Neil, for your expertise.
Thank you.
Thank you, Amy. Thanks, everyone.